This is a long list of legislation that passed through the New Hampshire State House and Senate in 2017. They were all bills that the Republican governor signed quietly, no fanfare, no televised bill sightings. And at first sight, it's a pretty mundane list. There was a bill setting rules for betting on something called simulcast racing, a bill about setting standards for dissolved oxygen in water, something about blood testing disorders. But buried in this long list of bills that the Republican governor of New Hampshire signed in 2017 was something more sinister. On this list, it was called a bill, quote, relative to domicile for voting purposes. Sounds pretty harmless, benign even. But what did that bill do? It made it harder for college students to vote in the state of New Hampshire. Now, that new bill signed by the governor required all students and other part-time residents of the state to become permanent New Hampshire residents to become eligible to vote. For any student who had a car on campus, that meant they were required to pay to register their vehicle in New Hampshire. They would have to go through the hassle of getting a New Hampshire's driver's license, too. Now, this bill was signed into law by the Republican governor right before the 2018 midterms. Critics argued that it would disproportionately affect college students who are predominantly Democratic voters. But think about it. Going to the DMV, paying to register your car, it takes time and it takes money. Most college students barely have the time to do their laundry. Many of them can barely afford a slice of pizza, let alone a bill from the DMV for several $100s. Let's look at one kid's story. He was attending Dartmouth when that legislation in New Hampshire was passed. He said the entire process of establishing his residency in the state took a full month. He needed a letter from his school to prove to the town clerk that he actually lived where he lived. He had to drive 45 minutes each way to the DMV to set up his new license. And then he paid $300 to register his car in order to establish residency in New Hampshire. The student likened the new tax to a poll tax, the price to pay in New Hampshire to access the ballot box. And so he sued. That Dartmouth student, along with a few of his classmates, filed a lawsuit to overturn that Republican voter legislation in New Hampshire, which they said encroached on their right to vote. And today, the Supreme Court in New Hampshire agreed. In a unanimous ruling, the highest court in New Hampshire overturned that Republican voter law of 2017. The court ruled that the law made it more confusing to vote and could deter people from trying to register. They wrote in their ruling that the bill, quote, imposes unreasonable burdens on the right to vote. And so they ordered that the law, quote, must be stricken in its entirety, which is good news for college students in New Hampshire. It's good news for democracy, because this is the way it's supposed to work. Everyone in this country, even if you live in a dorm or drove your car to college across state lines, which many people do, everyone over the age of 18 who is a citizen should have equal access to the ballot box. Well, today, the Supreme Court in New Hampshire righted that wrong. But that's not the way these fights are going everywhere. Just yesterday, the United States Supreme Court upheld a pair of voting restrictions in Arizona. One of those restrictions calls to nullify anyone's vote that was accidentally cast in the wrong precinct. The other blocks anyone but a relative or a caregiver from helping you turn in your absentee ballot. The legal challenge to those two voting restrictions argued that they disproportionately affected voters of color and therefore violated the Voting Rights Act. But the Supreme Court put those voting restrictions back on the books in Arizona. The conservative majority on the court argued that any unequal impact on voters of color was minor and did not violate the law. And this, of course, has sweeping implications for anyone living in Arizona. But this ruling will be felt way beyond the Grand Canyon state. This year alone, 17 Republican-led states have passed bills that make it harder for people to vote. Everything from voter ID laws, restrictions on mail-in voting, fewer hours to vote in person. Most of those laws disproportionately affect access to the ballot box for people who are not white. This ruling from the Supreme Court this week is basically a big green light to Republican legislatures, which are trying to make it harder for people to vote. It's signaling that any court challenges to this new wave of anti-voting legislation that we've seen this year could fail, like the challenge to the Arizona law just did. So if you're on that side of the fight, if you're trying to knock down these laws that make it harder to vote, where is your head at right now? Joining us now is Cecilia Wong. She's the deputy legal director at the ACLU, which filed an amicus brief with the Supreme Court, arguing that the Arizona laws in question violated Section 2 of the Voting Rights Act. Cecilia, thank you for being with us this evening. I think that's not common language for many people who are, relatively well read on the topic. What does that mean? What is the Voting Rights Act says you can't make laws that make it harder for an identifiable group to vote.
So what Congress meant when it enacted the latest version of Section 2 of the Voting Rights Act is that it wanted to expand the franchise and make sure that voters, all voters, but particularly minority voters, would not be blocked from their polling places through the machinations of state or local officials. But what we saw yesterday, as you mentioned, is in the last day of its term, the Supreme Court, by a 6-3 vote along strict partisan lines, upheld those two Arizona voting restrictions that disproportionately affect Native American, Latino, and Black voters. And those two provisions, as the Navajo Nation in its amicus brief and many others explained at the Supreme Court, really had the effect, after a long history of discrimination against minority voters in Arizona, of blocking many, many minority voters. So yes, yesterday's decision in the Brnovich case is a really deep blow to the right to vote in our country and therefore to the foundations of our democracy. But it could have been a lot worse. I think that's the main takeaway.
Talk to me about that. It could have been a lot worse.
So the petitioners in the case, including the Attorney General of Arizona, Mr. Brnovich, wanted to basically gut Section 2. Now, remember, the story actually goes back a lot farther than that. In 2013, the Supreme Court did away with Section 5 of the Voting Rights Act in a case called Shelby County. In Shelby County, the court said, all of the civil rights era cases and the laws that Congress enacted to get rid of Jim Crow restrictions on voting by minority voters that required pre-clearance by the Justice Department or by a federal court for changes to voting procedures in historically discriminatory jurisdictions, that law, Section 5, was no longer constitutional. So after 2013, we saw a number of state and local jurisdictions in partisan ways trying to block voters of color. That really stepped up after 2008, when record turnout drove all Americans, and particularly minority voters and Black voters, to the polls to vote for Barack Obama. And what happened since 2008 is you've seen just a rash of these state and local laws and policies that try to block Black, Latino, Native American, other voters of color. What the court did yesterday was to interpret Section 2 of the Voting Rights Act, which was another tool, really the main other tool that was left after the Shelby County decision in 2013, and just gutted it. But the petitioners, including the state of Arizona, were trying to get the court to say, you can't even get at discriminatory impacts or effects of these laws. You can only go after voter qualification measures. That would have been an extreme and extraordinary and atextual interpretation. And even this Supreme Court majority of 6, led by Justice Alito, rejected that rule.
But it's an important point. It's an important point, because at no point, I mean, I've had this argument with a number of people who say, show me where in the books it says that there is something here that is meant to impede the right of people of color to vote, of African Americans to vote, of Native Americans to vote, or people who live in a particular zip code. No law, even in Jim Crow, there were not laws that were all that blatantly designed to say, hey, Black people, this isn't for you.
And that's exactly right, Ali. What the majority did was just willfully ignore all that history, not only the history leading up to the last amendments to Section 2 in 1982, but also the history of discrimination against Native American and other voters of color in Arizona. It also ignored all of the evidence that the amici brought forth in the Supreme Court, showing what the present day barriers are for voters of color to go and cast their votes under these two policies that Arizona has instituted. So, for example, take the out of precinct rule, the one where if you vote in the wrong precinct accidentally, your vote is struck and you don't have any chance to cure your mistake in voting in the wrong precinct. Why should that be a problem? Alito says, no big deal. You got lots of ways to vote. It's not that hard to get it right when you go figure out where to go vote in person. Well, it turns out that because of certain factors having to do with lack of mailing addresses, with having the wrong precinct assigned to you by your county registrar, because of the lack of address, a lot of Native Americans who live on the reservation, including the Navajo reservation, tend to get assigned the wrong precinct, might make that mistake and never have a chance to fix it. Yep. Their vote is just struck. Similarly, this prohibition on third-party ballot collection, Alito makes it seem like no big deal. You have lots of ways to vote. If you want to vote by mail, drop your ballot in the mail. Turns out only 18% of Native American voters in the 3 counties that span the Navajo Nation's reservation lands have at-home mail service. This is something not known to a lot of us who don't live in those areas. And that's why it was so disproportionately restrictive of Native American voters to have these 2 policies in place. And those are the things that the Supreme Court upheld.
And right, for people who have never faced any impediments to their voting, it becomes difficult to understand that for people who do face impediments to voting, it's enough to make you not vote. So, Cecilia, thanks for your detail and the granular explanation that you've provided for what has happened. Cecilia Wong is the Deputy Legal Director of the ACLU.